Some time back, a person approached me and said that he wanted to get an FIR registered. I asked him about the offence that was committed against him, and he was giving me a brief idea about the facts. And suddenly he asked me a question as to whether stating a certain allegation would raise an offence under a specific act. Now, I don't want to name the particular act which was involved, but when he asked that question, I was like, okay, so this person has already done a research, and to be very specific, that particular act or any allegation made in it will most probably end up in the arrest of the accused, if at all the ingredients are satisfied. That gives you the idea that nowadays, a lot of your clients, a lot of informants browse through the internet. They get a very clear idea as to how they should be presenting a complaint before the police. Stating so and so facts would complete the ingredients of the offence that will be necessary to prima facie make out the allegations stated therein. So, it is also the case that in most cases, the parties only want a revenge against the other party. So, they want the other party to feel threatened, intimidated. They want them to be fearing arrest. So they will include a non-bailable offence forcefully. They will be including a cognizable offence so that the FIR is registered immediately. And all this is done by careful drafting of the complaint. Now you might imagine that this requires a lawyer, and only a lawyer can draft such a complaint. That is also true. It may be happening in many places, but I think having Google, everybody is capable of drafting these allegations so as to convince the police that a prima facie case is made out and an FIR must be registered against so and so person. It's a sad thing about law that this is happening. And how do you quash these cases? Is it possible to quash such an FIR that is cleverly drafted, that is so well drafted that all the ingredients are present? We know that generally in a petition that has been filed to quash an FIR under section 482 of the CRPC or under article 226 of the Constitution before a high court, the high court shouldn't be considering the evidence because it is not a trial. So they will leave the aspects which must be tried by a trial court to the trial court, and here they will only be considering the FIR as such. That is, if it is still in the FIR stage and it is not proceeded much into the investigation, when we will have more material before the court. We can refer to the case of Mahmood Ali vs. State of Uttar Pradesh. The case number is Criminal Appeal number 2341 of 2023. The judgment was pronounced on 8th of August 2023 by a division bench of the Honorable Supreme Court. Here the Supreme Court observed in paragraph 12 that whenever an accused comes before the court invoking either the inherent powers under section 482 of the CRPC or extraordinary jurisdiction under article 226 of the Constitution to get the FIR or the criminal proceedings quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with the ulterior motive for wreaking vengeance, then in such circumstances the court owes a duty to look into the FIR with care and a little more closely. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking vengeance, personal vengeance, etc., then he would ensure that the FIR or complaint is very well drafted with all the necessary pleadings. The complainant would ensure that the averments made in the FIR or complaint are such that they disclose the necessary ingredients to constitute the alleged offence. Therefore, it will not be just enough for the court to look into the averments made in the FIR or complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offence are disclosed or not. Further, it has been said that in frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averments, and if need be, with due care and circumspection, try to read in between the lines. The court, while exercising its jurisdiction under section 482 of the CRPC or article 226 of the Constitution, need not restrict itself only to a stage of a case, but is empowered to take into account the overall circumstances leading to the initiation or registration of the case, as well as the materials collected in the course of investigation. Here, the Supreme Court quashed the proceedings against the particular petitioner by looking at the surrounding circumstances, that is earlier FIRs that were being filed against him, and took it to mean that this is all a result of some private or personal grudge against the petitioner therein. So this gives you the impression that you can very well convince the court to look into the surrounding circumstances and also to read in between the lines of the FIR or complaint. So complaint here is not the information that is being given to the police. It is the complaint made before the magistrate under section 200 of the CRPC. So it is evident that you can challenge a complaint made before the magistrate on the same ground. Obviously, if a person is giving the police some information that is well drafted, the same could be done before the magistrate also. So in any case, mere reason that a complaint has been drafted very well so as to include all the ingredients of an offence doesn't mean the accused must suffer trial or must be suffering a very prolonged investigation. You can very well go for a quash and get justice. I hope you found this information very useful. Please do subscribe to Lawyers Society for more of these interesting videos on very interesting legal issues and interpretation of provisions, case studies, so on and so forth. We can learn together, and that is how I think we can proceed further in this very long journey of understanding what the law says. Thank you for listening. Until next time, thank you.